Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's been designed to address the relevant, critical, and sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. As always, we'd like to welcome and thank our sponsors from Odette Bazar Grasso law firm, Jackie Bazar, Jackie and David. Thank you. Today we're going to discuss our employment contracts. Not everyone needs them, wants them, deserves them. Who does and why would they? What does at will mean? Certainly there's non-compete clauses that are issues for people to consider. Discussing and negotiating such terms and conditions of employment may be awkward and difficult at times, especially when they can be contentious. Whether you are fired or whether you are firing someone, it might be good for you to know what the contract terms are or what the terms of your employment are well in advance. So this is designed to help both employers and employees. Today, the information should provide some news that you can use. So let's find out what you need to know and help you avoid some of the pitfalls at work. So Jackie and David, when we start out here, what are the basic issues about employment contracts?
Well, first of all, most people don't need employment contracts. Depends on the type of job that they have. Certainly, if you're in a sales position where you're dealing with consumers or other customers of the business, you might need a contract. So what are the things that go into it? Usually it's a term of employment. What's the length of time? What's the salary? What are the non-compete issues, if there are any in there? And what other territories might you be covering, and what are your what's the scope of your employment? What are the things that you're expected to do, your responsibilities?
Benefits as well.
And benefits.
In Rhode Island and in Massachusetts, can an employer fire or lay someone off, as they say, at will? What's the law?
What people need to realize is that in both states you are considered an employee at will, so you don't have a contract and you're not committed to any length of time. So that really means that, yeah, they can let you go, but they have to have good cause. Okay, so a lot of times what happens is you'll get laid off because of economic issues. But if there's cause enough to let you go, then you can do that, and there's really not much you can do unless you can prove that you were discriminated or if it was a wrongful termination. Certainly if somebody was insubordinate or there was some theft going on at the employers, then that's cause for letting somebody go. But you are an employee at will.
So the impact of that is, if you're fired for cause, you stole, you were guilty of malfeasance of some type, when you're fired, you won't be able to collect unemployment because you did something to cause your termination. If you're let go just because they don't want you anymore, they don't need you anymore, but they're not discriminating against you in any fashion, just they're terminating you, then you would be eligible for unemployment. But you might not have a civil case against them for doing that. If they let you go for a reason of discrimination, then you would have a legal claim against your employer.
Who actually gets the employment contract offered them? I mean, it makes sense that it would not be an average line worker, perhaps.
No, it's
maybe, I don't know. Who would be?
Usually you're highly salaried employees. So a sales manager, as David said, maybe a vice president of a corporation or a bank. We as lawyers sometimes will have employment contracts depending upon the nature of the practice and how large a law firm it would be. Doctors have employment contracts, so highly compensated employees typically. You see it a lot with sales positions as well. And
certainly we've had programs where we've discussed intellectual property. If you are dealing with a high-tech or an IT firm or someone who's doing new product development, we understand that there might be highly confidential information or designs or concepts. To protect trade secrets, would an employer of many more employees, many more wide and deep across their employment lines, would they be more likely to have someone sign something that secures, if not their employment, at least the trade secret? Or if you're going to do one, must you do both? If you're going to protect the trade secret, you also have to offer that employee some good reason to stay and a contract that says you'll be employed here for X years or whatever.
There's competing interests in this type of situation. The company may want you to sign an agreement not to disclose any confidential information. In fact, you might be required to do that anyway if it's a position that you're put in that you would only have that information by virtue of your employment. In any event, the company may not want to give you any term of employment for many reasons, one of which is under common law in Rhode Island, you're, as we talked about, an employee at will. They could let you go. Now, when you have a contract, then if they let you go, it could be considered a breach of the contract, and they may still owe you money under the contract. So as the employee, you'd want a contract that addresses, as Jackie said, the benefits that you're going to get, the salary, the length of your employment, and your job responsibilities. The company may not want to put that in writing, but certainly they want to protect whatever information that you're using on their behalf.
What you see often with large companies is you'll get a job description in written form from the employer, and it will detail your job duties and your salary and your benefits. But that is not considered a contract, especially since the employer 99.9% of the time puts language in there that says this is not to be considered as an employment contract. But it still is a written document. It's an acknowledgement by the employee. If there are trade secrets and you sign that acknowledgement and you later leave and you divulge trade secrets, or sometimes what happens is people take customer lists, then there are damages.
Right. And so that term sheet that Jackie's talking about would be terms of your employment, but not necessarily a contract. Another way employers will protect themselves is with a handbook. And many larger companies, and even some small ones, will create a handbook that lays out all of the responsibilities and expectations of employment, including vacation time, sick leave, those types of things. And they'll ask you to sign that usually as an employee to acknowledge that you have it and that you're bound by the terms of employment that are in the handbook.
Interesting. And in the case, if not a vice president or a high management level position, if someone is being trained by their prospective or their new employer, that takes time and commitment on the employer or the company's part. Might it be likely then that they would have an employment contract? Might that be a legitimate reason to offer or expect that your new hire would sign one? If I'm going to invest my time, energy in training you and making you a valuable asset to my company, I at least expect 1 year, 2 years, or something like that out of you in return. Is that a reasonable time, even if it's not for a vice president?
I think if it's someone being trained in a computer system, for instance, a computer programmer or maybe a data entry clerk, that's not something that you would typically say. If it is someone of a higher level, then yeah, I think that's reasonable to put that in writing.
But the company can't make you work if you don't want to work. There's no involuntary servitude.
Yeah.
So all they can do is create a term. What they can do to protect themselves, if they want and if it's appropriate, is to have you sign a non-compete clause that says that we're going to train you, you're going to learn certain skills that are applicable to our business, and we don't want you to go to work for some competing business. That they can do, and that would stop you from doing a job that's in that field, but it wouldn't stop you from just leaving to go do something else.
And I think it's important, if you do see a non-compete clause in a contract or any employment contract, seek legal advice. It's worth the maybe $100 or $200 per hour that you're paying, because non-compete clauses can be subject of litigation. So somebody might sign a non-compete clause that says you're not to compete within 60 miles of a Rhode Island radius. Well, that's pretty much all of Rhode Island.
And then some.
That really prohibits a person from earning a living. Now, is that reasonable? Probably not, because we have case law that says it has to be within a reasonable radius. So, for instance, somebody has Southeast Mass, maybe they could limit it to Southeast Mass for a sales position. But
it depends on the type of job, too, in the company. I had a case once where my client worked for a large online pharmacy company, which was really worldwide delivery, but certainly nationwide. And so his non-compete, which has to be reasonable in terms of scope, what are the types of things you can and cannot do for a competitor, who is the competitor, how do you define that, time, 1 year, 2 years, 3 years, what's a reasonable amount of time, and area. And on the area part, if it's a nationwide company that is doing business over the internet, a nationwide ban might not be unreasonable, whereas if you're working for a local pharmacy and it's, on a corner pharmacy 3 miles, 5 miles, 10 miles might be what's reasonable under those circumstances. Or if Jackie's saying you're a salesman with a territory of Southeast Massachusetts, well then banning Southeast Massachusetts, Rhode Island, and Connecticut might not be reasonable. So you have to look at what the type of work that is being done is, and then determine whether those 3 things are reasonable.
It sounds as though you've just given a prospective employer and a prospective employee some idea about what is considered reasonable. We understand that, in my reading here, that non-compete is a legal document, but in many cases, in many states, they are not upheld in court because it's denying someone the right to earn a living. And certainly, as you just pointed out, in Rhode Island, such a small state, or Massachusetts, depending on how the territory is defined, you could absolutely be tying someone's hands because of the geographical limitations. And one other point, when you were describing the radius, could it also be that someone would be restricted to what markets, if they were selling in a certain market, but maybe they could sell to a different aspect of the market, wholesale versus retail, or a certain kind of category? Would that also help the employer make a proposed non-compete clause reasonable?
Well, here's what happens. You're trying to protect your business in the type of business that you do. So the courts, as you say, actually look at them very closely. They will uphold them if they're reasonable, but it's a restraint of trade. You're infringing on somebody's ability to earn a living.
Yes.
So they are very careful in how they look at them and what they do with them. The case I was talking about with the online pharmacy, the scope was you couldn't go to another business that does online pharmaceutical sales. Well, the argument we made and what we were able to win and convince everybody of that was different in this job is he went from an online pharmaceutical company selling to consumers directly to one that was selling to nursing homes. So it was quite different. And it was a different marketplace, it was a different business model. So it wasn't competing with the original employer, so that non-compete clause did not prevent him from going to that job.
Interesting. I understand that in at least one state, California, they routinely discount these non-compete clauses, and geographically, I suppose they have lots of latitude. It's quite a big state, but apparently they are not really willing to uphold any of these non-compete, unless it was a trade secret or something, then I guess they do uphold it. Address, if you will, the story if you are lawyers, doctors, or someone in a professional field, and you happen to be both employed by the company, but you're a partner in a company, and you decide that you want to leave. Your partner wants you to leave, or you want to leave, however that works. How does client taking differ? How does that, you would be dividing a business. What does that mean, that you dissolve a business? How does that work?
Well, it's breaking up a partnership.
Yeah.
So if there's a written contract, there's a partnership agreement, then all partnership agreements do address that very issue if a partner decides to leave the practice. If there isn't a partnership agreement, then we have a uniform partnership code in both Rhode Island and Mass, so we would defer to that.
Which means?
Which basically means the state statute's going to dictate this is what happens when you dissolve a partnership. And that's in the case if there's litigation. So if you are dissolving a partnership or a corporation, and there's a lot of negotiation back and forth. So we have clients, you have clients, we have to decide which clients are going with which person, pretty much what is the property of the firm, okay? There's a lot involved.
And if there were physicians, a physician's partnership, they draw from a hat who gets A to M, and
a person is movable, so to speak. So if that person wants to voluntarily follow the physician, if the physician goes to a different practice, they have that right. So a person is not property.
so you as the owner of a business you do not get to choose which clients you take. In fact, it's the client who might choose to be with you versus the partner or whatever. Ultimately, that's the case?
That is correct, but there's a couple of other issues that are involved in that. If it's a doctor's or a physician's business, usually they bill the work as it's done. So whatever money is due and owing the receivables would be property of the partnership or the doctor's practice. The ongoing business, the future business, the client, the patient coming back to see the doctor is new business. And you can't tell that patient which doctor they're going to go with. They're free to choose. With law firms, any work that's been done is money that's been earned by the firm. That's an asset of the firm. That can be divided. If there's ongoing work that's being done on a file, that file, the value of what's already been done is owned by the firm. That can be distributed or dissolved on a dissolution of the business and passed out to the partners. But future work, the client comes back for something else, that client can go to whichever attorney in the firm they want to go to.
Or whichever doctor.
Or whichever doctor.
So if you talk about it from a business standpoint, the business entity, when you are forming a corporation, a partnership, are these issues best addressed ahead of time?
Oh, yeah.
If we dissolve this, we will split by client, by assets, this way or that way?
Well, you have no way of knowing what your assets are going to be if there's a dissolution. I mean, you hope that there wouldn't be a dissolution, but you do have to make sure that you have something in writing that deals with that. Whatever the assets are at the time of the dissolution or the split up of the partnership, then you definitely have to have something in writing when you divide up your assets.
There
and split
are a
up the
number
partnership.
of reasons a partnership or a corporation may go in different directions. So in an employment agreement, as we talked about before, there might be certain things you put in there. There are certain things you want to put into a shareholders agreement or a partnership agreement. What if one of the partners or shareholders dies? Well, that's very different than one of the shareholders or partners going into a different business or going into the same business outside of the partnership. So there are a lot of different ways to address those changes. On a death, oftentimes the company, the partnership or the firm will fund that with life insurance and have a procedure to buy the shares or partnership interest of the deceased partner from the firm, for example.
This is good information. What about if you were buying or selling a business and you have valuable key employees, and we were talking earlier about an employment contract, would it ever be that in the buying or the selling of a business, those key employees become part of what the value of that business is, and with them goes the purchase or the sale of an employment contract so that those key people stay and keep that business operating as it should for year 1, 2, or 3, or whatever? Is that likely to happen as part of a purchase and sale of a business?
Well, if the new business wants to retain the person that's subject to the employment contract, I would hope that they would have something in writing that does address that situation. Certainly if the business goes under, then you no longer have the contract. Employees, remember, they're at will too, so they're free to leave at any time. If they want to stay with the company, they can. There's value to them, of course there's value to them. But a lot of it is going to be contingent upon the terms of the sale of the business. If they want to keep the employees, then they stay. Doesn't mean you're going to get a new employment contract. It's just you're going to continue to be an employee at will. And I think in the situation with someone who does have a contract, it's up to the parties, the buyer and the seller, and the individual subject to the contract to determine what needs to happen.
So if
there should be something in the contract, too, that addresses the sale of the business.
But if somebody comes in and buys the stock of a business, they acquire the business, including all of its contracts and rights and responsibilities. So they would acquire that contract by buying the stock. The person who's the subject of the contract, the key employee, has all the rights that he had prior to the new owner coming in, which includes his right to leave if he wants to. One of the things you would want to consider in an employment contract, and in fact the one I had done when that fellow left one firm to go to another, was he was going to the other firm because the person he was working for was very important to him. And what we put in there is if that person ever left or the business was ever acquired by someone else, he would have the right to terminate the contract with a certain payout on doing that, because that was why he relocated himself from Rhode Island halfway across the country. So you do want to put that in the contract, as Jackie said. But it would be different than a company that came in and just bought the assets of a business, not the rights and responsibilities. One would argue then whether or not they acquire that contract, and certainly whether or not that key employee has any obligations under the contract anymore if the original entity he entered into the contract no longer exists.
So let me follow up with that for a moment. And if that person didn't stay, didn't go along with the baby, the new bathwater, would he have some restrictive, could he have a restrictive covenant imposed on him where he couldn't do business because it would be against that new entity for 6 months, 1 year, 2 years. Is that a possibility?
Sure it is.
It
And
is.
certainly if that company bought the stock and all the rights and responsibilities of the company, it could be argued if it was just asset purchase, it might not be any longer enforceable as to him. But what I would do, if I'm negotiating the terms of an employment contract, and that's an important consideration for you, is to put that right into the contract. If the business is acquired, you have the right to reaffirm the contract or get out of it.
So it sounds, while we were speaking earlier, that there might be value for an employer to work with an attorney to review the elements of a contract that they might put together as an employment contract or a non-compete. But it also sounds, from what you're saying, that there is at some level for a prospective employee to also bring a contract to a lawyer for review.
Sure.
Absolutely.
And specifically with some of these terms, that if they're listed at all, it might give someone a reason to think there's reason to pursue this. Although admittedly online, there's everything online. So certainly someone could go to Google how to evaluate an
Employment contract.
employment contract from the employee or the employer.
Well, that's not
standpoint.
advisable. It's certainly not
Right.
advisable.
Good.
For the minimal amount of money it's going to cost you, at least make an appointment and have a consultation with an attorney, whether you're entering into an employment contract or getting out of an employment
Right.
contract. Because if you do get out before the term, then you want to make sure you have something in writing that releases you from any obligations. If it's for a valid reason, like, I don't know, say for instance, your spouse got transferred to the other side of the country and you have no way of staying in this particular area,
Right.
make sure you get out and have something in writing.
And when a company is downsizing, for instance, or going through changes and they're laying people off with these agreements where their employment's terminating, they have to allow the employee an opportunity to go consult with an attorney to review whatever document they're asking them to sign as they exit their
Yeah,
employment.
sometimes you'll have exit contracts, you'll have severance agreements, and if somebody is over the age of 40, you have to consider the Older Worker Benefit Protection Act, which has to deal with age discrimination, and as the employer, you have to make sure you address all of that in the contract. It's a lot to think about. It's not something that you can just buy at Staples or get online.
Admittedly, in preparation for this, of course, I did go to do some online research, and there certainly are documents that do help you with a checklist of things to evaluate. But for the scenarios that you're describing and playing out, certainly I can see in comparing the two, there's a reason for all of the different scenarios that you proposed, none of which were wholly addressed. They might be something that you can consider. But of course, this is, again, not with the average line worker, but rather someone who's upper to middle level of
Right,
management.
although on the termination of employment agreements, that severance agreements or whatever they might be, they can be any employee
right.
that's leaving the company, that if you're presenting this to a group of people because you're downsizing, you have to make sure that you do it correctly so that there is no discrimination involved. Everyone is being treated fairly, and you've considered all of the issues that Jackie was mentioning and beyond.
Again, when you were talking about the at-will, which is something that most people have heard bandied about if you live in Rhode Island, Mass, and any other states that do business that way, the minute someone is saying that they have an employment contract for you to sign, doesn't that in part, well, it gives the employer some control, but doesn't it also limit him somewhat in that if there's an employment contract, he can no longer say, well, I lost business and you're gone, even though I promised you 2 years of employment at thus and such a benefit compensation package, et cetera. Now I want to get rid of you in 6 months because my business had a downturn. Didn't he just take that
Well,
option off the
Violated the
table?
contract.
let's closely read the terms
Of
of
the
the
contract,
agreement,
yeah.
because what if it says, if I lose business, I can terminate
He
you?
could actually do that? How could that be considered fair,
You can
David?
negotiate anything you want in the contract as long as it's an arm's length transaction, there's no overreaching, and you're not playing a position of power against someone who doesn't, an adhesion contract, so to speak. You can negotiate terms, so
That would be considered reasonable, that I can hold you to a 2-year
Well-
agreement, but you can't?
but you really can't hold me to the 2-year agreement
Okay.
because I can leave.
You can.
We talked about it already. You can't
certainly-
force me to work, I can leave. But as the employee, I want to know exactly what my rights are, and I want my attorney to go in there and fight for me to put in the terms that I want. No, you can't let me go. No, you can go out of business and let me go, but
There are consequences.
Yeah,
There are
exactly.
consequences.
What are the benefits I'm going to get? What's my severance package? The golden parachute. You see the top-level guys with those things in contracts all the time. If one bank gets acquired by another bank and I'm no longer the CEO of the bank, what am I getting? Well, that's in his employment or her employment contract.
I guess the other thing I wanted to ask about that is if someone is a highly sought-after prospective employee, would it not, and even if it isn't upper-level management, but maybe he has a certain level of expertise or training or skill, is it likely that an employer would want to specially prepare a contract to make sure that they use it as a bargaining chip to lure him to be hired and convince him that I really do believe in you, sir, and I want you on my team? Is that likely to happen for, now I'm addressing not the upper level, but maybe the middle and some other special categories?
It really depends on what the needs of the company is.
Right.
And if they need somebody and you fill those needs, you might have some leverage to do that.
And ask for one, might you?
Sure.
No, you as the prospective employee can ask for one as well. It's not always, the burden's not always on the employer.
Right.
So you want to be able to secure your certain employment, especially if you're leaving a job with the promise of a new job. I would definitely get something in writing.
Especially, suppose if you had to move cross-country
And then they withdraw the offer. So
Right.
there are consequences to that as well.
Right. And so you may not get an employment contract, but you certainly might say, I'm relocating. I'm coming here for this particular purpose. I want a contract that says, what compensation are you going to give me if I don't have the job after a certain period of time? So you can let me go, but you're going to compensate me for my moving expenses or whatever other issues that you think are relevant to your needs on that circumstance.
And then to put this in a context, knowing today that the job market is very competitive, if you, as a prospective hire, were likely to ask for some sort of employment contract because of some of the scenarios that you put forth, are you likely to be frowned upon and not considered to be as viable a candidate, or is that a black mark against you for wanting some sort of guarantee?
Again, it depends on the nature of the job
Yeah.
and the level of employment and salary.
Right.
Really
And how
depends.
much the company needs you. So if they need you, then use the leverage.
Yeah.
And, there's another way that people's rights are protected in jobs, and that's unions, because unions have contracts with employers, and then if you're a member of the union and you're working under that collective bargaining agreement, you're protected by those rights. And in some cases, you've got both, because baseball players have collective bargaining rights and contracts.
And they also have someone who's working for them. Most of us
Agents.
don't have agents who are negotiating and making sure that they're fair play. Do lawyers ever get involved in making sure that the compensation is fair if someone doesn't have the wherewithal to be able to find that themselves? Is
absolutely.
that something that's reasonable for you to consider?
Absolutely.
Sure.
Yeah.
Lawyers, like agents in baseball contracts, can certainly negotiate contracts for people. That's something that we do every day, actually.
Really?
Sure.
At all levels?
Yeah, I mean, we negotiate all different kinds of contracts. I don't mean we're out there negotiating people's employment contracts, but negotiating contracts, negotiating settlements of automobile accident cases, workers' compensation claims. It's all negotiation of terms of an agreement.
Sounds like that's
And
helpful.
a contract is an agreement.
Good to know. We've actually covered quite a few topics about employment and businesses. Thank you for tuning in. The discussion of legal matters continues. Join us.